Cody Kloepper was convicted of first-degree rape, first-degree burglary, and first-degree assault following the attack of a woman who was beaten with a metal bar, raped, and left for dead. She survived but required 43 stitches to her head, suffered a broken wrist and shattered arm. Her hands are permanently disabled. Mr. Kloepper was sentenced to 25.5 years. Evidence against him included his DNA on a piece of the glove used by the attacker, his physical description, his unauthorized presence at the apartment when the attack occurred, his decision to cut his hair shortly after the attack, and the fact he had access to the victim's apartment key and there was no evidence of forced entry. Shortly after the conviction, the Innocence Project obtained evidence of a second man's DNA on the glove and the victim's clothing. Cody Kloepper and this man had been intimate hours before the attack, so one of these men was the attacker. Other relevant evidence included the fact that the second man was Hispanic with a strong accent, and the victim's description of her attacker was of a tall white man. On March 5th, 2024, Cody Kloepper brought his case to the Washington Court of Appeals. Let's take a look.
Welcome to the State Court of Appeals. My name is George Fearing, and I will be presiding over our hearing. We have one hearing left on our docket, State versus Kloepper. On behalf of Mr. Kloepper, here today is Mr. Link. Am I correct?
You are.
And on behalf of the state of Washington is Mr. Blur. Mr. Link, how much time would you like to
I could have
reserve?
5 minutes.
Okay, please proceed.
Good morning, Gregory Link on behalf of Cody Kloepper in this case. It would have mattered to the jury in this case to know that Sal Contreras' DNA and semen, but not Mr. Kloepper's DNA, were all over the rape victim's clothing in this case. That was especially so if they also knew that he had lied twice to police and that he had lied to them. It would have changed the outcome. And I'd suggest that if the standard for a new trial is not met here, not met in any case, Mr. Kloepper is entitled to a new trial. The state would be free at that trial to present its new theory. But that's the place for it to be. So let's start with the only question that's at issue here, and that is, would it probably change the result? And before we start down that path, I think it's important to understand what that doesn't require. It doesn't require actual innocence. It doesn't require would be acquitted. And it's not a question of did the state have sufficient proof to convict Mr. Kloepper? Of course they did. If he hadn't, the jury wouldn't have convicted him. If they hadn't, he would have won a reversal on appeal. If any of those were the criteria for a new trial under the rule, we wouldn't be asking for a new trial. We'd be asking for outright dismissal. That's not the standard. And the standard in this case is simple. If we take the new evidence, the evidence of Mr. Contreras' semen and DNA on the rape victim's clothing, but not Mr. Kloepper's, and we add it to what the jury did here at trial, would that have changed their verdict? And I think it's impossible, in light of the facts that were presented to the jury, to say it wouldn't have mattered to even one juror. I think it's doubtful that it wouldn't have mattered to all 12 of them.
Is there anything in the record, whether Mr. Contreras has an accent or not? I thought that there was something in the record, and I didn't quite pick up on where it was, but I remember seeing something that said he had an accent.
I apologize. I don't have the answer to that question.
Okay, because I do know that the victim here testified that it was a white person, but obviously we've all heard the difference between how someone who may not be from the United States, or how someone who might have an accent, they wouldn't be described as a white person. And I don't think that Mr. Contreras fits the physical description as far as long bushy hair and over 6 foot. Is there a description as far as how tall Mr. Contreras is?
There is in the record, and right off the top of my head, I want to say he was 5'10", 5'11".
Okay, so he was close to 6 foot at least. But if there's something about an accent, then that's something that might be.
I'll be honest, I don't recall.
Okay, thank you.
So if we examine what was in front of the jury, what we know is that this is a single assailant assault. We know that there's no possible explanation in the jury trial record to explain how Mr. Contreras' semen and DNA would have ended up on the rape victim's clothing. There is not a single fact that would support that, starting with the fact that there was no evidence of sexual contact. In fact, Mr. Contreras told the jury, when specifically asked by the prosecutor, was there sexual contact? He said no, there wasn't any. That's what he told the jury. So that's the starting point. We have a single assailant case with no possible explanation to explain how his semen and DNA came to be on the rape victim's clothing. Now, that might leave us all asking questions, how? But that's not a basis to deny the new trial. That's the purpose of the new trial. And that's where the trial court got it wrong. And I think we also have to understand the magnitude of this evidence. DNA is, we all know, some of the most powerful evidence jurors ever know. I cite some studies in my case that suggest that jurors say it is the most powerful evidence they will ever consider. That's why the state dropped the charges against the original suspect when they got a YSTR DNA result. It's what caused the victim to change her identification after adamantly identifying someone else to now adamantly identifying Mr. Kloepper.
Well, wasn't Mr. Klepper's DNA found in at least one piece of evidence, a tip of the glove, I believe?
Yeah, well, it's described as a glove, but as a matter of fact, it's a piece of latex.
Right.
We don't know what it was.
Yeah,
it was described
part of the latex glove, or probably a glove, yeah.
His YSTR there, which is a non-discriminating test, that simply meant that 1 in 500 people in the Tri-Cities at that time could have been the contributor. Yes, it was, and Mr. Contreras's was the other sample that was in that glove.
Does it have to be a male contributor?
It does have to be a male contributor, which is why it's only 500. But that's nothing like the evidence they had here. 1 in 54 quadrillion that semen belonged to anyone.
Well, we know that there were probably both DNAs found in the apartment. I think the record's fairly clear on that, whether it's 1 in 500 or 1 in a billion. 1 in 500 is still pretty clear that Mr. Klepper's DNA was in the apartment.
His DNA was on that piece of rubber that was not, but his semen was not on the rape victim. There was no DNA recovered from the rape victim that was Mr. Contreras's. And again, we have no explanation for how Mr. Contreras's semen could be there. Again, he denied that there was any sexual contact. So we don't have any evidence in front of the jury that explains how his semen came to be on the rape victim's clothing.
But later on, when there was another hearing, there did become an explanation, but you just never been able to test on cross-examination, or have you?
Again, if we start with what he said at trial, and that's where we stop, because again, what he said at that new hearing, that is not part of the analysis.
Okay.
The analysis is take the new evidence, the DNA and the semen, compare it to what the jury heard, because the jury didn't hear that there was sexual contact. Again, he adamantly denied it. Now, at that new hearing, he allowed that maybe there was. He still denied that there was sexual contact, even though he allowed maybe he ejaculated. I don't think any reasonable juror hearing him say there was no sexual contact had any room in their mind of what sexual contact meant that would have allowed them to say, but he ejaculated on Mr. Kloepper and his semen found its way 10 miles across the city to this rape victim's apartment. He denied sexual.
In a hearing on the motion for a new trial, is the state also allowed to bring in evidence that was not submitted during the trial?
I'm going to submit to you that a hearing on a new trial isn't an evidentiary hearing. It's a point at which the parties get to argue about the impact.
So what's the answer to my question?
The answer is no.
Okay, and you have case law that
There
says
is no, because I think the standard is so clear that all we're doing is taking the new evidence and comparing it to the existing evidence. This isn't supposed to be a mini trial. That's the point of the new trial. Again, I suggest to you that the reason we don't have cases addressing it is because courts have understood that's not the way this process works. I think Bradshaw suggests that, Bradford, not Bradshaw, suggests that is to be the case, that if you've got a new theory that explains it, if you've got new facts that'll explain it, that's the point of the new trial. But it's a really straightforward question. Knowing that there's no possible explanation for his semen to be on the rape victim's clothing, and yet it's there, would it have mattered to a jury? The answer has to be yes. Now, I want to go back to your question, Judge Lawrence Berry, that if we have that new evidence, we have to credit that evidence too, because now Mr. Contreras is actually contradicting what he said at trial. And he understands it because when he was asked, you said there was no sexual contact. He says, I don't think I said that. And he did, because he understood there was no world in which no sexual contact allowed for his semen to be on Mr. Kloepper. We all understand that. And what he says at this motion for a new trial now is, well, maybe I did. He's still not certain it happened. So again, if we're asking, could it have mattered to the jury? We have to bring in the fact that he's still not certain it happened. And we have to bring into the fact that he's saying something different than what he told you the first time. And the jury gets to wrestle with that and ask, is he telling me the truth now?
Okay, the test, let's say that we agree with you that the test is that this new evidence would be sufficient to cause one juror to vote differently, for example, to acquit. Therefore, you don't have a unanimous jury and the result might be different, okay? It's a hung jury. Let's say we agree with you that it's the one juror standard. Wouldn't that one juror then have to ignore all the circumstantial evidence that the state presented? How do you get around that? There's a lot of circumstantial evidence.
Jurors do that all the time. Trials are about conflicting evidence.
Yeah, but the test really is, would one reasonable juror discount all the circumstantial evidence? For example, the circumstantial evidence is that the person who attacked the woman here, that he had a key because there was no forced entry. We have the admission by the defendant that he got his hair cut the day after the attack because he said it was too similar to the victim's description of his hair. We've got the fact that he was dishonest about where he was that night. And I think that there's at least 3 or 4 other things that was pretty strong circumstantial evidence that was used to convict Mr. Kloepper. Wouldn't they have to disregard all of that? And isn't that unreasonable?
No, the answer to that is A, it's not unreasonable, and B, it can't be deemed unreasonable. Because again, the only time we ever get to a motion for a new trial is after a jury believed the evidence, right? The question's not, was there enough evidence for the jury to believe? There was. It was a circumstantial case, but there was.
Yeah.
And there always will be. There will be stronger evidence than that in cases that merit new trials.
But
because the evidence here, and again, I don't think I can emphasize this enough. The evidence here is extraordinarily powerful. Another person's semen on a single assailant rape victim. I understand the state will stand here today and say they would have gone to trial. I'm going to submit to you that's absurd. They would not have gone to this trial knowing that Contreras' semen was on the rape victim based on the evidence they had at trial. They had a circumstantial case. But would they have even prosecuted that case? And I'm going to tell you,
Mr. Link, you're into.
I understand that, Your Honor.
You may continue if you wish.
I will just to finish the point. I think it is absurd to suggest they would have, and I think it is absurd for the trial judge to have concluded that the evidence of the semen on a single assailant rape victim would not have mattered. It would have, and Mr. Kloepper is entitled to a new trial.
Mr. Blur.
Good morning.
Good morning, Mr. Buller. I have the same question that I asked Mr. Link. When the accused brings a motion for a new trial based on newly discovered evidence, may the state also submit new evidence for the court to review?
That's obvious. The obvious answer is that if there's new evidence, the state has a chance to rebut that. Let's say that
by introducing evidence that the state did not introduce at the time of trial.
Correct.
Okay, and
Correct.
Can you cite me a case that stands for that?
No, I'm sure there are many cases in which something like this happens. A victim recants her testimony against a defendant, saying he wasn't the one that raped me. In fact, I was never raped. I was elsewhere at the time of the offense. We're allowed to bring in evidence that the victim was right here, right there at home, wherever she was. And I can't imagine that there's not a chance to rebut new evidence. It's new evidence that is not known before. Of course, we should have the chance to rebut that. My name is Terry Bloor.
I'm sorry. Did I not allow
Oh,
you to
that's okay.
introduce yourself?
No, that's okay.
I apologize.
No, that's fine. My name is Terry Bloor, and I am a deputy prosecutor with Benton County, and I've been on this case from the beginning. I charged Carl Goring. I charged Cody Kloepper, and I followed this through with the direct appeals. The issue in this case is whether or not you believe that the trial court judge abused his discretion in deciding that the defendant didn't prove that new evidence would result in an acquittal. And with all due respect to my colleague, I think that's probably one of the few legal issues that we disagree on.
Doesn't the standard say a different result? It doesn't say acquittal, a different result.
Yes, but this case of State versus Davis that I submitted refers to an acquittal or a conviction for a lesser offense. And
Hung jury qualify?
what's that?
Does a hung jury
No.
qualify?
No, it's not a result. A hung jury is not a result. And I would say that you're familiar, this court is familiar with this aspect in a different context. In the context of ineffective assistance claims, for the prejudice prong, you have to believe that the result would be different because the defendant would be acquitted. And
I don't think that's true. I think we just have to have some reservations as to our confidence in the verdict.
well, I would still say that I think that I disagree with the court respectfully. But
You may do so.
okay.
Let me ask the question that I asked Mr. Link earlier. You're familiar with the record, obviously. You've been through it a number of times. Is there evidence that Mr. Contreras?
Contreras.
Yeah. Is there evidence that he had an accent?
Well, in the record, I asked the judge at the hearing on the motion for the new trial to find that Mr. Contreras did have a strong Spanish accent or Mexican accent. The judge wrote over 100-page opinion, and he did not touch on that aspect of it.
Okay.
So,
So in other words, the record isn't official that he has one, but you wouldn't have probably asked the judge to say that unless you noticed something.
correct.
Well, that probably neither here nor there, but we'll have to see. Okay.
And he testified live at this hearing,
Yes.
correct?
Yes.
Yes.
And was a stenographer that took down what was said as opposed to a tape recording?
I can't remember, to be honest with you. I can't remember. I believe that possibly we've submitted tape recordings of Mr. Contreras speaking. I believe that there might be a interview with him conducted by the police. But I don't want to
Well, if these questions do remind any of you that there's something in the record on this issue, it would be very helpful if you guide us where it is in the record.
okay, I will endeavor to do so and
Again,
advise
because
you.
I think what we all agree is that the conviction here is based upon circumstantial evidence, a lot of circumstantial evidence. And as Judge Fearing indicated, is that, we want to review the overall record to get a sense whether or not this new evidence undermines our confidence in the verdict. If Mr. Contreras has a thick accent, that would, be inconsistent with the victim's description that it was a white guy, a white person who raped her.
And could I outline the facts
Sure.
against the defendant? Okay, the victim in this case is a middle-aged woman. I think she was in her 40s, who lives alone and always locked her doors. She lived alone in a 4th floor apartment complex. She always locked her doors. On the night or the early morning hours, she checked the door. She said to the 911 operator, she checked the door to make sure it was locked. And then somebody came in through a means and attacked her. That person had to have a key because the police didn't find any forced entry. As you said, Judge Lawrence Berry, the defendant made efforts to conceal his identity on the day. You said it was one day later. It was on the day that the attack happened.
Because the attack occurred early morning, right?
Yes, like maybe 4:30, 4:10, in that ballpark. And the police interviewed him, Mr. Kloepper, that afternoon. And by that time, they knew that the victim had described the perpetrator as having shaggy hair, and Mr. Kloepper, as of that date, had shoulder length hair, and he buzz cut it, almost buzz cut it.
Mr. Blore, it's my understanding that this rape was done just digitally. Was there any?
Yes.
Did the assailant ever expose his penis? Or is there any allegation that he made any contact with her with his penis?
I don't believe so. She said that he tried to get something in her vagina or her anus. She believes that was a finger. She had a towel put over her or a hood put over her so that she couldn't see the perpetrator. That's one thing. The defendant had access to her apartment key, and Mr. Contreras did not. Mr. Contreras did not try to change his appearance.
Mr. Contreras, excuse me, and Mr. Kloepper, he was seen in the apartment building very early that morning, which was unusual.
Yes, it was against the rules.
And he admitted, or he explained that he had slept there that night.
Yes.
Which was against the rules.
It was against the rules again.
Okay. And the amount of DNA that was found on the victim's clothing, it was consistent, or was entirely consistent with a transfer DNA rather than direct DNA deposit.
Yes. And
And is that because the amount was so small amount of the DNA found in the clothing?
Yes, I think that's significant. If a man ejaculates, he's gonna have millions of spermatozoa. And on the victim's clothing, very few spermatozoa were found.
Yeah, they're like
less than
1,
20.
2, 3, maybe on one
Yeah.
situation, there was 9 perhaps, but
Correct.
usually it's 1, 2, or 3.
But, and all of that though was Mr. Contreras's
Yes.
sperm, correct?
Yes, but I'm gonna say.
And I
that,
thought that scientists could not distinguish between transfer DNA and original DNA.
That's absolutely correct. And
So,
actually,
but you're saying that this was, they could tell this was transfer DNA.
no.
Okay.
I thought that was
I'm
your
not
answer.
saying.
That's what my question was. I was curious about that.
No, I'm not saying that Contreras left his DNA in the apartment. I'm saying I'm saying that was transferred based on all of the circumstantial evidence. I'm going to disagree with my colleague respectfully again. Absolutely, we would have charged this case if we knew that the Contreras DNA was on the victim. Absolutely, we would have said that proves it.
You would have still charged Mr. Kloepper.
Absolutely. The only way that got into Ms. Widrig's, the victim's apartment, is for to be transferred from Contreras to Kloepper to the victim. That proves it. That proves absolutely that we've got the right person, and the DNA from Mr. Kloepper was fairly weak, you know, it was,
100?
well, it was one in 440.
Okay.
But fairly weak. But this absolutely proved that the only person who could have deposited that DNA was Mr. Kloepper.
How did the sperm get from Mr. Contreras to the clothes of Mr. Kloepper?
He ejaculated during while Mr. Kloepper touched his chest and hugged him.
Even though Mr. Contreras still had his clothes on.
Yes. Well, he said he was wearing shorts, but Contreras said that he was wearing shorts.
Okay.
But yeah, and actually the hearing at the motion for a new trial admitted, the defense admitted that there was a transfer. The question was who transferred DNA from Kloepper to Contreras, and I think,
or vice versa.
What's that?
Or vice versa.
Yes.
Okay, and your time has.
But Kloepper, Contreras didn't know anything about the victim. He didn't know where she lived.
Okay, your time has expired, Mr. Blur.
Let me
Any
ask
questions for Mr. Blur?
I do have one question. I want to make sure I understand this point. The DNA that was consistent with Mr. Kloepper on the piece of the glove that was found in the apartment. Are you saying that it was consistent with both Mr. Kloepper and Mr. Contreras? I think that's what it is. In other words, we can't definitively say that this DNA did not belong solely to Mr. Contreras?
The major contributor of that piece of latex, probably the blood, was Mr. Kloepper. A minor contributor, according to the lab, was Mr. Contreras.
Okay, so there were two DNA samples or specimens there. Okay,
Yes.
okay, because that's an important point. Thank you.
Okay. Thank you,
Okay,
Mr.
thank
Blur. Mr. Link? Mr. Link, how does Mr. Kloepper explain how Mr. Contreras got into the apartment without there being any forcible entry into the?
I don't know. That's not the point of this inquiry. The fact that we can't answer that question, that's for a jury. We're not here to prove his innocence. We're not here to prove an acquittal. Again, that's where we need to start from. We don't have to explain. And I'll tell you, the fact that the state's evidence doesn't explain how it happened doesn't mean their theory's right. It may mean they didn't investigate it right because they decided it was Mr. Kloepper. They didn't test the clothing. Because the question you have to ask is, how did it get there? How did Mr. Contreras' semen get on the rape victim's clothing, but not a single piece of Mr. Kloepper's DNA? How did it get there? The fact that their case at trial doesn't explain it justifies the need for a new trial if they want to go that route. It doesn't prove their case. I don't think I've ever heard a prosecutor say that another man's semen on the rape victim proves that we charged the right guy. And yet that's what they're saying here today. It doesn't prove they got the right guy. It might prove they didn't investigate to answer that question, how did it get there? But the fact that the question, how did it get there, remains unanswered isn't for us to decide. That's for the jury to decide. Because I'll tell you, the jury that heard this case, they couldn't have answered that question. And I got to tell you, it really would have mattered to them. I can't imagine a person hearing those facts from that trial thinking, hey, you got the guy, good, strong circumstantial evidence. But someone else's semen is on the rape victim, and it doesn't matter to one person. And if we're going to talk about all the evidence that's so overwhelming as the state would have it, well, there's contradictory evidence too. So if we're going to reweigh the evidence, the state doesn't get to start with saying, well, the jury believed us. Mr. Kloepper's significant other said he came home at 8:30, didn't leave until the police came. So when did he get this haircut? What about the fact that the victim looked at several identification processes that included Mr. Kloepper, who she knew, and didn't identify? Or the fact that she told Mr. Guerin's attorney it wasn't him, and I'm adamant it's Mr. Guerin. What about that? The evidence isn't as strong as the state would have you. It's enough to sustain a conviction. I'll grant them that. But again, that's why, again, I started by saying this isn't about could the state convict him, because they did. Every motion for new trial will involve circumstantial evidence or better. And yet we still have to ask the question, would it have mattered? And again, we can't start by saying but they proved him guilty. And that's what the state's entire response to this motion has been. We proved him guilty. How'd it get there? I don't know the answer. Mr. Bloor doesn't know the answer. And I bet this court and the folks here today don't know the answer. But that's not the question that we have to answer. That's thankfully the question that 12 other individuals should be answering. And I'd ask the court to give Mr. Kloepper that opportunity to let those 12 people figure that out. Thank you.
Thank you, counsel, for your excellent presentations. The case is submitted.
Following these arguments, the court concluded the trial court did not abuse its discretion when it denied Mr. Kloepper's motion for a new trial. Share your thoughts below. Do cases like this change how much confidence we place on DNA evidence? Please consider subscribing for a new court video every week. It's appreciated. Until next time.